semester, and we're glad to see a lot of you continue to come out. I'm Jack Hill, I'm the president of the Federalist Society here at the University of Texas, and I'm very happy to have Professor Josh Blackman here today, as well as Professor Vladeck, who, as usual, is being very generous with his time and joining us. So without further ado, Warner Scott, our speaker chair, will introduce our two professors participating today.
Thank you all again for joining us today. So Professor Blackman is an associate professor of law at the South Texas College of Law in Houston, who specializes in constitutional law, the United States Supreme Court, and the intersection of law and technology. He is the author of the critically acclaimed Unprecedented, the Constitutional Challenge to Obamacare, and Unraveled, Obamacare, Religious Liberty, and Executive Power. He is an adjunct scholar at the Cato Institute and the founder of Fantasy SCOTUS, the Internet's premier Supreme Court fantasy league.
You should all play.
And I'm sure you are all familiar with Professor Vladeck by now, the A. Dalton Cross Professor of Law at the University of Texas, has argued for the Supreme Court in the past and this term, and we wish him the best of luck.
We do.
So.
Maybe.
Okay. Thank you all so much. It's a pleasure to be here. Steve and I are old sparring partners. I think we've debated maybe 5 or 6 years in a row, going back to his time at American Law School in D.C. The topic today is not a new one. It's an old one. And I feel like I'm in the movie Groundhog Day, where the same issue keeps repeating over and over again, and I get to give talks about it over burritos and lunchtime. In 2010, Congress enacted the Patient Protection and Affordable Care Act. This was a comprehensive law. Okay, so I've done it before. On the count of 3, everyone take your burritos out of the foil because it makes a very annoying noise. Ready? 1, 2, 3, go. Do it. Some of you aren't doing it. Just do it, please. It's very distracting. This is why I recommend not wrapping. Don't give wrap foods for these talks. Okay. Thank you. Okay. In 2010, Congress enacted the Affordable Care Act. This was a comprehensive law that changed the way health care is operated in the United States. The essential component of the law was a provision known as the individual mandate. It said, with certain exceptions, you shall maintain insurance during certain periods of time. The failure to maintain insurance would result in paying a penalty. That's how the law described it. Shortly after the ACA was enacted, litigants across the country challenged the constitutionality of the mandate. Again, they challenged the mandate as being unconstitutional. What was their basis for injury? Well, the law wouldn't actually go into effect until 2014. That is, the penalty would never kick until 2014. The only basis for injury in 2010 was the mandate itself. And the plaintiffs argued that the requirement to buy insurance forced them to rearrange their financial priorities to get insured and be ready for the mandate when it goes into effect. Again, the penalty played no role in the standing question in 2010. The case goes to the Supreme Court, and we get the decision of NFAB versus Sibelius, 2012. I'm sure you've all read this in common law. If not, you will read it soon. Okay, what was the holding in NFAB? Complicated. It is. There were 5 votes that found that the mandate was an unconstitutional exercise of the Commerce and Necessary and Proper Clause powers. Chief Justice Roberts plus the 4 conservatives. They recognized that Congress cannot use its commerce powers to compel people to purchase insurance. Okay, that was the first part of the opinion, part 3A of the majority. Let's call it 3A. We get to part 3B and 3C of the majority opinion. At this point, Roberts is no longer with the conservatives. He's with Ginsburg, Breyer, Sotomayor, and Kagan. They pivot. Roberts says the court has a duty to uphold laws if it's feasible. And in this case, the Congress can enact this law as a penalty, but Congress could have enacted this law as a tax on going uninsured. Now, the court said Congress did not do that. Congress did not enact a tax on the uninsured. But what Congress could have done was simply enacted a tax on the uninsured. Why does this matter? Roberts says because this law can reasonably be read as imposing a tax on those who go uninsured, we can uphold it. In other words, the law that Roberts upheld was not the law that was enacted. Under the Roberts saving construction, there was no mandate. Roberts said there was no mandate for purposes of saving construction. It was merely a tax on going uninsured. And he said that reading is plausible because, in many regards, a penalty looks like a tax. It's paid to the Treasury. You put it on your tax return. The same tools to collect taxes can be used to collect the penalty, right? This is, for all intents and purposes, a tax, even though they didn't call it that. Therefore, the ACA was upheld. Okay, that was NFIB. Over the next few years, the ACA was sort of like in this limbo where political attacks were coming left and right. But none, was that? Right. That's a good point, yeah. They were coming all from the right. I think that my friend Steve with a healthy correction. But then we get to 2017, right? There were efforts to repeal the mandate in Congress, and those efforts failed. There were not enough votes. Famously, John McCain put his thumbs down. Remember that one. But then Congress enacts the Tax Cut and Jobs Act of 2017, the TCJA. This was a big law, did a lot of things which I don't really care about, but it did one thing that was very important. It modified the penalty. It reduced the penalty to 0. Now, Josh, what do you mean? Why they just repeal the penalty statute? They couldn't. Under the mechanism in place, the voting process, they could only make what are called financial changes, what's called budget reconciliation. All they could do was drop the penalty down to $0.00. That's all they could do, and that's all they did do. They didn't modify any other aspect of the ACA. Now, as Congress was voting this, I thought, the penalty is not raising more revenue. I guess Obamacare is unconstitutional. I recognize this. I don't think I was the only person. I wasn't. Texas, the Attorney General, and others brought a suit. And they argued that because the penalty no longer raises revenue, the ACA is now unconstitutional, right? Because the saving construction no longer holds, the mandate cannot be saved. And because the mandate's unconstitutional, the remainder of the law goes down. Okay, this litigation was litigated in the Northern District of Texas. The district court judge found that indeed the ACA was now unconstitutional. In fairness, he cited my article several times, so I can't hate it too much, but I disagree with a few parts of the opinion. The case was appealed to the Fifth Circuit. It was argued, I think, in June or July over the summer. The decision may come out any minute now, maybe even while Steve is up here and I are debating. So I expect a decision probably by the end of this month, but who knows. My goal here is threefold. I first want to address standing, right? My second, I want to address the merits. And third, I want to address severability. So I want to put those into 3 different buckets. So the first issue is standing, right? The argument goes like this. To get to federal court, you need an injury in fact. And there's cases upon cases describing what injury in fact is. Josh, how can it be that a mandate that has no penalty creates an injury in fact? Right? How can it be that a toothless mandate, right? A toothless mandate gets you into federal court? Now, a lot of people today are saying this word toothless mandate. The first person I know who said it was actually John Roberts. During the oral argument in 2012, he actually asked the lawyer for the plaintiffs, how can it be that a mandate that's toothless, right, that there is no penalty in effect now? How do you get into federal court? The lawyer said a requirement to buy insurance is an injury. You're making me do something I do not want to do. Now, you may not agree that's an Article 3 injury, right? You may think that's too tenuous, too speculative, right? That's not real. It's not concrete in the lingo. But the court upheld it, right? The court in NFIB found that was a valid basis for standing. Standing is jurisdictional, cannot be waived. The only basis for standing asserted was the mandate inflicting an injury, and the court found standing on that basis. As far as I'm concerned, standing's resolved, right? We can argue whether that was correct. Maybe it was a drive-by standing ruling. Maybe not, I don't know. But the same mandate that was in effect in 2012 is in effect today, right? The mandate and not the penalty was the basis for a jurisdiction in NFIB. And I'm okay in standing on those grounds. But I agree, it's sort of a novel basis for standing. I think there's some other possible bases, you have tax forms to fill out, but the mandate itself, I think, does provide the basis. The second position concerns the merits. This is an argument which I think is actually the easiest of all 3. If the mandate no longer raises revenue, the ACA can only be construed as a tax. Let me say it again. If the penalty is not raising revenue, then the ACA can no longer be construed as raising taxes. I think this flows pretty naturally from the Roberts opinion. And to be frank, the interveners in this case don't really argue otherwise. They basically say, well, Your Honor, if you want to declare the mandate unconstitutional, we'll just leave it there, right? They don't actually argue otherwise. There's some arguments to the contrary. For example, maybe someone was required to pay the penalty in 2019, but delays or taxes for a couple of years, so it will generate revenue in the future. I think there are arguments to the contrary, but I don't think they will decide the day. I think at a minimum, the courts will say the mandate's unconstitutional. Let me just stop there. If nothing else happens, but the court declares the mandate's unconstitutional, I'm okay with that, right? I'm not in this for the severability argument. That's something that I'll talk about. That's not why I care about this case. I, for years, have actually defended John Roberts. I think he actually believed that his opinion, NFIB, was the best way of reading the statute. I do. I firmly believe that. I don't think he was going, I mean, I was depressed about it for a while, but I don't think that he was doing something improper. I think he did what he thought was the best way of doing it. And if that's what he thought, and now we have no revenue, then the requirement is to say that the mandate is unlawful. If he does nothing more, then I'm okay with that. All right. Let's go on to severability, right? Severability is kind of a weird doctrine, right? And I use a very gross image to describe it. Imagine you have a toe with gangrene on it, right? Gross, right? You have a toe with gangrene on it. What do? Well, maybe you can just cut off that toe and you'll be fine. But maybe the infection spread a bit. You have to cut off a couple toes. Maybe you have to amputate the foot. Maybe you have to amputate below the knee. Maybe the entire leg has to go, right? Or maybe the infection has spread so pervasively that the entire corpus, the entire body is gone and the patient is lost. That's sort of how severability analysis works, right? Congress enacts this very big statute, and maybe there's one part that's unconstitutional. So perhaps it's possible just to sever or cut off, right? Literally, amputate the unconstitutional limb and leave the rest of the statute in place, right? But maybe the infection is so pervasive that the entire statute has to go, right? We've seen severability work in funny ways. A Texas law, I'll mention, Holman's Health versus Hellerstedt from 2016. Right, this was the Texas abortion law, the Wendy Davis bill, you might recall. This law had provisions which required doctors to have admitting privileges and required abortion clinics to have what are called surgical standards, right? There were other provisions that weren't really important. Like all abortion clinics have to have smoke detectors installed, right? Does anyone think that a smoke detector requirement is an undue burden? Not really. But the court declared the entire statute unconstitutional, right? That none of it could stand, right? Justice Breyer said that that we can't pick and choose. The entire law's got to go. Okay. Now, is that the right approach to standing? There's a second approach that has been gaining some currency recently, which I've become somewhat receptive to, and that was advanced by Justice Thomas. Justice Thomas wrote an opinion in Murphy versus NCAA, right? This was a complicated case about whether the federal government could prohibit gambling in states, right? Online sports gambling, right? I could care less about sports gambling, but the severability question is important. Thomas said this. He said, look, it's very strange to have the severability doctrine, right? Because usually if a plaintiff has standing to challenge provision A, he can only challenge provision A. But severability lets him say, we're going to challenge provisions A, B, C, D, and E, right? It lets you go beyond Article 3. Thomas argues that there's a jurisdictional problem with severability doctrine, right? That lets plaintiffs set aside laws that they don't have standing to challenge independently. Thomas says we should only be able to declare unconstitutional those laws which actually harm, that is, injure the plaintiffs. I think Thomas might be right. Maybe not. Maybe I don't think there's a majority in the court to declare that. I don't know, maybe 2 or 3 votes. But Thomas very well may be right. And I think this has implications for things like overbreadth doctrine, right? In the First Amendment context, courts routinely declare laws unconstitutional, even if the plaintiff himself, his speech, can be prohibited. Okay. Why do I give you that spiel by Justice Thomas? If Justice Thomas is right, then the remedy in the ACA case is not to declare the entire ACA unlawful. The remedy is to only declare those portions that actually injure the plaintiffs. And I think that's where the court's headed. We had oral argument in New Orleans in June or July, and I was at the court for that argument. And a couple of the questions from the bench suggested a familiarity with Thomas's opinion and perhaps a preference for it. And at least one of the judges in the panel asked if a remand was appropriate to decide what provisions actually injure the plaintiffs. Now, DOJ, Department of Justice, I think is quietly pushing this position also. It's been popularly reported in the media they want to kill the entire law. If you actually look at what they said in their briefs and what they said in argument, that's not their position. They want a remand to determine which provisions actually injure the plaintiffs. Now, that may be a lot or may be a little. I don't know the answer to that question. Like, there's some provisions of the law that won't harm them, like, you have to post calorie counts on, billboards, at restaurants, or that you have to have certain regulations on medical devices, right? A lot of the law will not injure private plaintiffs. They just won't. I expect what the court will simply do is issue a remand and say, go back to district court. No, you don't declare the entire law unconstitutional, but you can declare specific portions unconstitutional that will injure the plaintiffs. Okay. What if I'm right? What if that happens? Well, no doubt we'll get a cert petition. I don't think the interveners will waste their time on the en banc process. They're not going to get it in the Fifth Circuit. I think they'll go right to the Supreme Court. Generally, I'd say the court will be hesitant to grant review in a sort of high-profile political case, except you only need 4 votes to grant cert. And I think Ginsburg, Breyer, Kagan, and Sotomayor may do a defensive cert grant, basically force the chief to decide this case now and not after the election. And if it goes to the court, I can see the Chief Justice saying, well, we find that the mandate's unconstitutional, but we send it back down to the district court to decide what happens next. And that kicks this well beyond the election. Again, the Fifth Circuit may take its time. Maybe we won't get a decision until March or April. Again, this is not a preliminary injunction, right? This is a regular appeal. And in the Fifth Circuit, a regular appeal can take 6 months to resolve, up to even longer. So unless the dissenting judge can hustle it, I don't know if we'll get a decision this fall. Maybe yes, maybe no. But I think that's the path forward. Now, let me just leave you with a couple points before I give it over to my friend Steve. Without question, this case is political. I don't say that lightly, but it is, right? It's brought by an elected Republican Attorney General in a reddish state, perhaps. And this was more or less sort of, I won't say payback, but like a making up for the 2012 decision. Like, they weren't happy with the 2012 decision. They weren't happy with the way the repeal vote went in Congress, and that this was another shot to try and take down the ACA. I'm not going to argue with that. I think that's an accurate description. My position is more narrow, right? For years, I've written about the ACA and the mandate, and I've tried to articulate understanding the Roberts opinion. Right? Most people think that Roberts upheld the law as a tax. That's not right. Some people even think that Roberts said that there's no mandate. That's also not right. Roberts said that the most straightforward way of reading the law is a mandate to buy insurance. But under our duty to uphold laws, we can construe it as a tax because it raises revenue. The law can only raise revenue, therefore you can't make that assumption, and we're left with an unconstitutional mandate. What happens beyond that is actually, I don't say I don't care, but that's not my game. That's not why I'm here. But I do think the severability argument will be important to see what Justice Thomas does, perhaps Justice Gorsuch as well, and see if the Fifth Circuit picks up on that. I think it's my 15 minutes. I thank you all for your attention, and I turn over to my friend Steve, and we'll have a nice discussion. We'll take questions at the end. Thank you.
Do you mind if I sit here?
Yeah, sure. It's whatever you want.
So it's hard not to be deeply cynical about this lawsuit. And it's hard because we have a lawsuit that's predicated on a series of disingenuous legal theories that were adopted, as I think I took Josh to concede, in response to Congress's refusal to do what its proponents actually wanted, filed in a very carefully selected district court to ensure a friendly judge, and now with the full support of the Trump administration, which both lies on a regular basis about what the lawsuit would actually do, and claims to have an alternative that, according to media reports, is a figment of the president's imagination. In those circumstances, I think it's hard to sort of treat this as a pure abstract legal debate over the doctrine of standing and the doctrine of severability, which I'll get to, but I think we need to actually, the context, which Josh largely, I think, jumped over, not because he doesn't know it, he is the world's leading authority on it, but I think is important. So let's do some context. So Josh started in 2010 when the ACA was enacted. I want to start in 2009 when, according to the government's own data, over 50 million people were uninsured. That's 1/6 of the United States population, either by choice or more likely because they could not afford private insurance and or did not qualify for government aid, right? So the major national social problem Congress was addressing in this statute was trying to reduce the number of Americans who are uninsured. Of those uninsured individuals, in 2009, the executive branch, HHS, projected that they consumed more than $100 billion in healthcare services, or over 5% of the nation's total. And so Congress was responding to the question of how do we actually incentivize and or require and or provide access to meaningful health insurance for these individuals. So the ACA actually had two centerpieces. Josh focused on the individual mandate, which is part of it, but it's also worth stressing the significance of the Medicaid expansion, that it was just as a central part of the ACA that Congress was expanding the eligibility for Medicaid, so that instead of it being individuals who were at an income level at or below the federal poverty level, it raised it to 133 to 138% of the federal poverty level, which was projected to include 20 million Americans who previously were uninsured. I say all of this because when Josh says, if all that the Fifth Circuit does is strike down the individual mandate, I'd be okay with that. I think that was a direct quote. I am not okay with that. And I'm not okay with that because I think it's important to understand the problem Congress was trying to solve and to try to actually put it into context of what doctrinal innovations are necessary to get to a point where you can strike it down. All right. Now, in the 10 years it's been on the books, I think it's not an exaggeration to say the ACA has not worked perfectly. I think there have been plenty of flaws in how it's been implemented, some of which because of litigation, some of which not. But it has been successful at its principal goal. The government and the Kaiser Family Foundation estimate that now 20 million Americans are insured today who weren't 10 years ago. With the exception of the last 2 years, for the first, 5 years the ACA's provisions were in force, we saw the number of uninsured Americans decline steeply each year, with some corresponding effects on the overall average cost of health insurance, which are often, I think, blown out of proportion in the press, but those are there. All right, so that's the backdrop against this. Josh mentioned the first ACA lawsuit, NFIB versus Sibelius, where the court upholds the individual mandate but strikes down the Medicaid expansion and renders the Medicaid expansion voluntary as opposed to mandatory. Still, most states volunteer for the Medicaid expansion because it's an incredibly good deal. Only the states where the politics overrode the sweetness of the deal did not voluntarily comply with the Medicaid expansion, where the government was paying 100% of the money up until 2019 and now 90%. But there was a second ACA lawsuit too in King versus Burwell, where Chief Justice Roberts again joins the more progressive justices to reject what was at least largely a statutory challenge to the way that state-created exchanges were operating under the Affordable Care Act, but that I think everyone understood had the potential to destroy the ACA if it succeeded. And I say that because I'm not as, when we get to the sort of projection, I'm not as sure about the Chief Justice as I think Josh is, or at least I don't know that my prediction would be where Josh's is, but we'll get there. All right, so Josh talked about the three sort of substantive issues before the Fifth Circuit: standing, the merits, and severability. So let's start with standing. It's worth noting the lawsuit was filed by Texas. Right? There are individual plaintiffs in the lawsuit. Josh talked about the individual plaintiffs. I'll talk about them. No one has explained to my satisfaction why Texas has standing to bring this lawsuit. Right? That is to say, in the original 2012 case that the Supreme Court heard, everyone, myself included, agreed that the states that sued challenging the Medicaid expansion had standing because the Medicaid expansion operated directly on the states. The courts ultimately all held that the states that were just challenging the individual mandate, like Virginia, did not have standing. I think that distinction holds up here. So it's worth stressing that like the main oomph behind this lawsuit, the originally 20, now 18 red states, are actually parties who, to my mind, have no plausible claim of Article III standing at all. As for the individual mandate, plaintiffs, of whom I think there are two. So Josh says quite rightly that the argument is that the individual mandate no longer injures them, right? Because the penalty was zeroed out by Congress in 2017. Of course, that's indisputable. Congress zeroed out the penalty, that was the whole point. But here's where I get a little bit concerned. Let's just see, right, the whole point of the law was to eliminate, right, the injury the plaintiffs were complaining about. The whole point of the 2017 law was to say, you no longer have to comply with this mandate. If you don't comply with the mandate, the worst thing that happens to you is nothing, right? There's nothing that goes on your credit report, nothing goes on your job application. There's no box you have to check. I did not have health insurance this year, despite the zero penalty, right? There are no consequences after the 2017 tax law for failure to comply with the mandate. To my mind, that's a pretty powerful sign that there's no injury in fact sufficient for Article 3 purposes. But reasonable people, Josh is a reasonable person.
Wow.
Usually.
Thank you. I'll take it.
Can disagree with that. Note what the disagreement hinges on. To disagree with that, you have to take the view, I think, and if I'm missing something, please, you have to take the view, right, that there's an Article 3 injury in fact because the mere specter of compliance, right, the pressure one feels to comply with legal mandates, even those that produce no penalty, is injurious, right? That it's impacting these individuals. That they feel like they have to comply with the mandate even though non-compliance comes with no real penalty. Let's assume that's true. I'm not one to second guess, right, the beliefs of people who aren't me. Note what that does to the merits, right? So now all of a sudden we're saying, even though the penalty has been zeroed out, it is still having an effect, right? Even though the penalty has been zeroed out, it is still inducing these two people to feel compelled to buy health insurance lest nothing happen to them for failing to do so, right? That suggests to me that the zeroing out of the penalty is actually not failing to raise revenue, right? Because if the whole point of standing, if the whole standing argument turns on the idea that individuals are still being psychologically compelled to buy health insurance lest they be penalized with nothing, then Congress is still raising revenue. Because these individuals, right, are in fact buying insurance. It's not direct revenue because they're not paying it to Uncle Sam, right? But it is having the exact effect taxes are designed to have, right? It is encouraging and shaping the behavior of the taxees. So to me, right, it's one or the other. Either they're injured, in which case they're injured, and therefore it still actually does quite seem to me like it's a tax, or they're not injured, in which case they're not injured, and there should be no standing. I don't know how you can sort of so easily cleave the space between them. All right, so that's sort of big objection number one, right? No one has standing, and the best argument for standing also is a pretty good argument on the merits. Let's assume you disagree, because the Fifth Circuit, I think, certainly will. Me versus the Fifth Circuit, it's not, we might agree that today is Monday, but there might be a concurrence. So let's assume, right, that we get to the point where Josh, the point up to which I was totally agreeing with Josh, where all that happens is the court strikes down the individual mandate, right? Well, I think everyone agrees that with the individual mandate would have to fall at least two other provisions, the guaranteed issue and the community rating provisions. Those of you who had me for common law, we talked about how those three provisions rise and fall together. But the severability point past that gets very awkward in a hurry. And I want to suggest both the substance of the severability argument and the way it has unfolded raise some serious lawyering concerns. So first, Josh analogizes severability to gangrene. Colorful as that may be, I actually think it is a deeply incorrect frame. Because the question in severability analysis is not supposed to be whether I, as a judge, think that striking down this one provision infects the rest of the statute or not. The question in severability analysis is supposed to be, what would the Congress that enacted this have wanted to happen if it had known that this provision would not be on the books? And the reason why that's the question is because otherwise, severability is just an excuse for judicial power, right? Otherwise, severability allows judges to rewrite statutes by fiat, as opposed to, in the context of remedying a constitutional violation, figure out and try as best as they can to be faithful agents of the legislature. That's how the Supreme Court has described severability doctrine consistently for 107 years, since the Yazoo case where it really has its origins. And with all due respect to Justice Thomas, I think that is how most of the justices still understand their job in severability cases, is what would Congress have wanted? Now, that's not always going to be easy, right? As we've talked about in my common law classes, I will talk about at length if any of you are dumb enough to take me for Fed courts.
You should. You should take
right?
it.
Severability doctrine is not exactly objective because it's counterfactual. Right? That a lot of that analysis then asks what Congress would have thought about something Congress wasn't thinking about, which is actually much of how we do Erie, for those of you who have taken Civ Pro, which is not nearly enough of you. Right? I'm not saying that severability doctrine yields objective answers. I'm saying it is supposed to be tied to congressional intent so that it's not just an excuse for judges to write the statute they want to write. Now, what does that mean in this context? Well, in this context, the severability argument, near as I understand it, is that the Congress that zeroed out the penalty in 2017 would not really have wanted the rest of the statute to stick around. That their goal was actually to repeal the ACA in its entirety, and it was only because of the procedural obstacles imposed by reconciliation, to which Josh alluded. Procedural obstacles, by the way, that every Congress deals with, that they were unable to get their real goal, which was repealing the ACA altogether. Okay, but the statute that they're now proposing to strike down was not written in 2017, it was written in 2010. And the Congress that wrote that statute not only had a very particular view about severability, but produced a Supreme Court decision called NFIB, where a 5-4 majority concluded that the statute was meant to be severable. In the process of severing the unconstitutional feature of the Medicaid expansion, right, from the rest of the statute. So it seems to me that the notion, the argument that has been made, not by Josh, but by some of the plaintiffs in the Texas case and by some of the supporters, that the whole statute must fall, is utterly disingenuous, is unsupported by precedent, is inconsistent with NFIB itself, and would have cataclysmic effects because of all of the things that would fall. Right? The Medicaid expansion, even in those states in which it's voluntary, would be wiped off the books. There go all of the new millions of Americans who for the first time were given access to health insurance and affordable health care. Right? HIV treatment programs, opioid programs, hundreds of things that no one disputes were in Congress's constitutional power to provide for would fall. Seems to me that that's not really something we should be seriously entertaining. Finally, Josh, I think, is a little defensive of the Justice Department, which is unfortunate because I think the Justice Department in this case has engaged in about the most indefensible litigation activity I've ever seen. By the Justice Department. It's a higher bar. So let's talk about the Justice Department. Josh knows, and I think most of you also probably know, that the Justice Department has a statutory obligation to defend federal statutes, to defend the constitutionality of federal statutes in court, so long as there is a reasonable basis on which the statute can be defended. I think it's a close call to me on whether the Trump administration was therefore defying this obligation when DOJ came out against the individual mandate early in this case. But I'm willing to chalk that one up as a close call. What is not a close call is the Justice Department taking the position, which Josh says they don't take, and this is a hill I will die on, that in fact the whole statute is unseverable. Not only do I think that position is itself...
That's not exactly it. Not that it's unseverable, that everything has to be enjoined. There's a difference.
Okay, first, in the notice it filed in the Fifth Circuit, right, they said that they were going to defend Judge O'Connor's decision in its entirety, right? O'Connor's decision is that the statute is unseverable, right? So therefore, DOJ said it was defending a district court decision holding the statute.
We agree on the notice, but not in the brief. The brief deviated.
At the end, the last sentence of the brief says what Josh said. Josh doesn't quote the rest of the brief, parts of which actually do suggest that DOJ's position is that the whole thing is unseverable. But here's why this matters, right? There is not a reasonable basis in law, let me back up again. DOJ is supposed to be defending statutes as long as there's a reasonable basis in law to defend them. I can't imagine there's an argument that it is unreasonable.
I agree with you on this point. I think DOJ is wrong.
Right. Okay. Good.
I don't defend DOJ on this position. We actually agree.
Okay. Well, but it's worth. I mean, our agreement should be taken for what it is, which is just how bad DOJ's position actually is in this case. And here's why this matters, guys. Right? I mean, I don't mean to get sort of fired up. Well, I do, but. The question is what kind of precedent you're setting, right? So the Obama administration, I think, rightly received a lot of criticism for the position it took vis-a-vis DOMA, right? Eric Holder, when he was Attorney General, filed a very, I think, contentious letter explaining that the Obama administration was no longer going to defend DOMA insofar as the question of the standard of scrutiny was unsettled. In essence, what Holder was arguing was, if it's up to us to argue what the degree of scrutiny is, we think it should be intermediate scrutiny, and therefore we think DOMA is unconstitutional. But in those courts that have already decided the question of scrutiny and held its rational basis, we will defend DOMA. One can quibble with that argument, Josh has. That is so much more nuanced than this.
I agree.
And the precedent you set by having the Justice Department not defend prior statutes based on theories that are themselves quite dubious, when there are not just reasonable, but to my mind, obviously meritorious grounds on which to take the other position, is one we should all be discomfited by. All right, so what happens going forward? Josh, I think, is probably right that unless the Fifth Circuit goes the ultra-cynical route and holds that the interveners lack standing, which would be an interesting indication of chutzpah, right? The plaintiffs have standing, but the interveners don't, would be a very strange way to decide this case. Unless they do that, I think odds are, yes, they will strike down the individual mandate. They will hold the plaintiffs do have standing, even though they don't. They will reconcile the positions that I think are irreconcilable. And I think Josh is probably right that they'll punt on severability, because I think the court will understand just what kind of a lightning rod that is versus individual mandate. But if this does go back to the Supreme Court, I guess I am not nearly as convinced as Josh is that the chief won't see this as a direct assault on him. And that the chief won't sort of look at his votes, for which he has received all kinds of criticism in NFIB and in King versus Burwell, as standing in the balance. And that the chief won't actually just dig in and say, no, I've upheld this twice before, I'm doing it a third time. I'm not convinced that's not going to happen. So to me, right, why all this matters is twofold. First, the severability piece is really going to go a long way toward how big or little of an impact this case actually has. If the Fifth Circuit actually says, guys, yes, individual mandate bad, but we're severing it completely, which they might do, then this actually doesn't have that much of an impact legally, because there's already no penalty, right? And the Medicaid expansion goes along, and all of the non-controversial important stuff under the ACA goes along without difficulty. It's the severability piece that matters. But also, and more generally, and then I'm going to shut up and let Josh tell me everything I got wrong. It's also the hubris of it. And this is, I think, I am not usually one to be critical of legal theories that I disagree with just because I disagree with them. But in this context, I really have a hard time separating out the naked political ambition animating this litigation from the substantive bottom line of the case. And I don't know that a world in which we keep just sort of throwing every possible rock at controversial domestic policies until one of them pokes through is a stable one that's good for all of us. So anyway, my thoughts in a not very well organized nutshell.
That's very good. Thank you, Steve. Thank you. I'm always grateful. Steve and I can agree without yelling at each other. I think it's a good model.
No, we can't.
I withdraw my criticism.
That's too easy.
That's too easy. But we can agree without yelling at each other often. I'll start with Steve's last point, and I'll go to some of the finer points. In 2012, if the Chief Justice has simply ruled that Congress's commerce powers allowed the mandate to exist, we wouldn't be here, right? If John Roberts did what Lawrence Silverman did on the D.C. Circuit, Lawrence Silverman was a very conservative Reagan appointee. He said, come on, where could we fill burden? Gonzales, your rage. Of course Congress can regulate a multi-billion-dollar industry. Had Roberts simply done that, we would not be sitting here, because repealing the penalty, zeroing out the penalty would make no difference because there's no saving construction. Instead, Roberts did what he did. He basically wounded the ACA. He thought, well, let me just write this opinion, and it'll probably never come back to haunt me. I was actually blogging about this in 2013. There were some places in California where the price of insurance was so high, it actually was no longer a tax, became a penalty, it was oppressive. Like, I actually blogged about this. I was actively considering, if Roberts' opinion was sound, what ways could be used to challenge it. Now, call me cynical. I want to see Roberts meant what he said, and maybe that makes me an awful person, but I believe when Roberts said it, he meant it. So the way I look at it is that Roberts basically wounded the ACA. He could have just upheld it entirely, but he wounded it. He wounded the Medicaid expansion without question by making it voluntary. And the question now is, what's the effect of subsequent congressional action? Now let me get to some of the weedy issues. I think Steve's argument on the raising revenue is creative. I haven't heard it before. Have you written about that or no?
No.
Okay, first time I've heard it. I think it's very creative. If the Roberts saving instruction said if it raises revenue in an indirect way, then I think Steve works. But the Roberts opinion is very specific about raising money for the IRS. So I just don't think it gets in there, which means the standing issue is not the hurdle. I don't think standing is the hurdle. I think you get past that. Now, on severability, Steve's right. My gangrene example was meant to be colorful to explain it, but always the question is not whether the patient will die, but the question is what would Congress have wanted to happen?
Congress wanted to die.
Would Congress want this person to die, right? I guess these are the death panels we were warned about. But the question... No?
No.
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 But the question...
Not the death panels.
But the question is not just what Congress have wanted. The question is which Congress have wanted. Now, I think, Steve, you may have misspoke. I don't know. You referred to the Congress in 2010, what they intended. That's not the party line in this case. The party line is what the Congress in 2017 intended. If we go to Congress in 2010, they told us very clearly that the mandate was essential to the law. Essential. Don Verrilli in the Obama administration argued that the 2010 Congress argued that you could not have the mandate without the other provisions, the guaranteed issue and the community rating. But the four joint dissenters, Scalia, Thomas, Kennedy, and Alito, argued beyond that. They argued that if the mandate goes, the entire law has to go. If this case is based on the 2010 Congress's intent, it's good for Texas. Now, the interveners argue that the Congress's intent in 2017 should matter. How do we know that? Because Susan Collins told us, right? John McCain told us. They went on Congress, they went on CNN, they said, well, we don't want to kill the rest of the ACA, we only want to kill the penalty, it's an unpopular part, right? If this case turns on what members of Congress thought in 2017, it's a fairly easy case. But there's an old decision, which you may have never heard of, called Frost versus Commissioner. It's an old case in the 1920s, and it goes like this. You have legislature number 1 and legislature number 2, right, at 2 points in time. The second legislature takes an unconstitutional act, right? They take an old statute and render it unconstitutional. Their actions then a nullity, we go back to the original one. If we take judicial supremacy seriously, which I don't, but if we do, that's what happened here. The Congress in 2017 rendered the ACA unconstitutional, at least in part. They screwed up. Maybe that wasn't their intent, but they did it. They modified a statute and took away the thread holding it together, which was the penalty. Now, I've written this before. Perhaps the correct remedy in this case is to kill the tax cut, that the court can reimpose the penalty, restoring the ACA's constitutionality. I don't think that's an insane answer. Again, I don't think that's insane. But if you're laughing in agreement, you recognize there's some merit here. Now, I don't think that's possible in this case because
the tax cut.
Right, you just kill the tax cut, you reinsert the penalty, right? That's not an option here because the plaintiffs haven't asked for it. The courts can't readily impose remedies that aren't asked for. Maybe they can, but they shouldn't. But if we take this seriously, with the 2017 Congress there was a nullity, their intent becomes irrelevant. And we're stuck with the intent from 2010, which is the mandate is essential to the rest of the act. Okay, that's all I got.
I just have one quick thing, and then we can throw up some questions. And the Supreme Court, by a 5-4 vote in June of 2012, the 2010 Congress's intent was that the statute was severable.
They didn't reach it. Roberts didn't have to because on the...
He severed the
no, but that was Medicaid expansion. That was a different element of the opinion.
So parts of it are severable.
Very good. Well, I think Roberts made up... Roberts, the ACA has no severability clause. The ACA has no severability clause. Roberts' discussion of whether the Medicaid expansion could be voluntary was saying, here's a saving construction. This is not what Congress intended. He said, this isn't what Congress intended, but I'm going to do it anyway. So it's not what Congress intended. It's what Roberts wanted. The judge wanted only some states of people to die, not in all the states.
Well, on that deeply candid note about the effect of the arguments you're making, let's throw it open to Q&A.
Okay. I guess we did yell on that last one. All right, questions? Nothing? Nothing we said elicited question? Okay.
So on the standing part for the Attorney Generals specifically, I know...
Attorneys General.
Yes.
Thank you.
Attorneys General, my bad.
This is one of my pet peeves is that we refer to attorneys general as general, right? They're not generals.
I don't like that. We agree. I think the Solicitor General is not a general.
Nope.
Okay.
But you know who's an admiral? The Surgeon General.
He is an admiral.
Okay.
Anyways, this isn't fully fleshed out because I only read it as a submission to the journal. But there's an article floating around the pool that's arguing that attorneys general should essentially be standing in more often for where we would usually use class actions, particularly where money is not really at issue, either to invalidate statutes or just get companies or entities to do X.
Like the new parents patriae.
Right, and their argument is, I guess, that standing is based off of the representation of the people in the state that are affected. And I'm wondering
So you want to do that one?
if anything, that means for your analysis of standing here.
Oh, it means for me.
Well,
Look, I've not defended Texas as standing in this case. The argument, which I'll try to sketch out, is that the ACA imposes some reporting requirements on them, right? And the argument is this.
Wait, reporting requirements which Texas is not challenging.
Yes. The argument is because the mandate, there are some reporting requirements that are triggered downstream, right? But they're not challenging the mandate because it only applies to individuals. I haven't defended Texas as standing argument. I think that the individuals have the argument. But I think the parens patriae argument was resolved in the Fourth Circuit opinion in a case called Cuccinelli versus Sibelius from 2011 or so. So I don't. If this is just based on Texas, I think it's a tough time. Now, I think Steve probably agrees on that point.
I do. I just say two things. First, really quickly, the reason why Texas is going for the jugular on severability is because it needs to in order to have standing. Right?
Yeah.
Texas's argument for why it has standing is because the unconstitutional part of the statute, which doesn't affect Texas at all, would cause the rest of the statute to be struck down, which would injure Texas because then they wouldn't have to comply with these little reporting requirements anymore. This is why I'm cynical. All right. On parents patriae, I mean, I've actually written about this outside the context of the ACA. I mean, I think it makes a lot of sense to allow states, through whatever mechanism their constitution allows, whether it's the Attorney General or some other entity, to act as parens patriae of their citizens when the defendants are anybody other than the federal government, right? So suing other states, suing private corporations, suing individuals, yes, I'm all for it. I think more states should do it. The problem when it comes to suits against the federal government is that states aren't parens patriae when it comes to federal law, right? The federal government is. And so there's a Supreme Court case from 1922 called Massachusetts versus Mellon that I think says quite powerfully and correctly that states generally don't have standing simply to enforce the rights of their citizens against the federal government. And I think there are good normative reasons for that beyond just the structural ones. This litigation, I think, underscores what would happen in a world where states were always allowed to sue. Basically, just every administration from the word go would be beset by states to its extreme, right? Whether it's, California suing Trump or Texas suing Obama, walking right into court just because it's possible one of their citizens might be harmed one day, maybe. And that's just not how we tend to think about justiciability. So I'm very pro the idea if the party on the other side of the V is anyone other than the federal government, but I think there are really good reasons not to do it if it's the federal government. And many of which are articulated in the Fourth Circuit decision Josh referenced.
Nothing
really?
on Obamacare?
Times have changed, man.
We have to yell more.
This is what Trump does to us.
We're jaded. This is pretty. There's not even a nationwide injunction in place. My God, who even cares? Is there no? Yes, over there.
Does it matter if we adopt that or not? Because California's still suing Trump, Texas still suing Obama.
But they're doing it based on their own proprietary interests. So, for example, like the DACA case this term, it's being brought by the University of California Regents, and they have students who are affected by DACA, so they're actually bringing this suit on behalf of their students and their faculty and other employees. So it's not actually parens patriae, it's behalf of like their own proprietary entities.
Right, I mean, when Florida sued in the first ACA case, right, Florida wasn't suing on behalf of its citizens, Florida was suing on behalf of itself. And so, just to be clear, I'm not averse to the idea that states will sometimes, can and should sometimes sue the federal government. Common law is littered with cases called state versus United States, right? New York versus United States, we just read right in our common law class. So the problem isn't just the specter of states, it's states suing in a case like this, where their real objection is that the federal government's doing something unconstitutional that doesn't actually affect the state directly.
Yeah, I agree. Any actual ACA questions? Man. Yeah.
Why does the sheer fact that a tax raises zero revenue make the tax unconstitutional? Like, I'm not seeing the logic there.
Okay. Roberts had a couple parts of his opinion, right? One part said is that the law is best read to impose a mandate and that it's a penalty, not a tax. But the ACA as a whole can be read as imposing a tax because it raises revenue. It's not that a tax that raises zero becomes unconstitutional. It's that the law can only be read as a tax because it raises zero revenue. I think that's the thrust of the saving construction.
Okay. That makes sense. Thanks.
Yep, my pleasure. Man, no one cares about this topic. I think Steve's right. I think there's been a jaded. There's just like on one Friday last week or 2 weeks ago, there were 4 injunctions issued in immigration cases, like 4 in one day, and it's like, all right, whatever. It's Friday, right?
And none of those 4 were the most important judicial decision.
No, that was the same day as the tax return case from New York. So I mean, I think people are just.
I was thinking DC Circuit on the Mazars.
Wasn't it also the same day as the Second Circuit put a stay on the?
It's hard to keep track.
But just it's. I think people are just jaded and dead. Just nothing. Oh man.
Can we go into questions? Yeah.
Okay, one more.
This is very broad, but does the resolution of this case have any impact on future DNC candidates' plans to do more nationalized health care?
No. Let's back up a second, right? This is why I think it's helpful to put this whole conversation into the broader context of the healthcare debate more generally. Universal healthcare, right, or single-payer healthcare is perfectly constitutional. We already have it. It's called Medicare, right? It's just eligibility is limited mostly to individuals who are 65 or older, right? And try as some folks might, the constitutional challenges to those programs have never succeeded. The objection to those programs are political, right, not constitutional. I don't think that changes no matter what comes of this litigation. I mean, the great irony of Obamacare is that this had been the Republican counterproposal.
From Pierre Delecto.
From Pierre Delecto and his buddies.
That's Mitt Romney, if you're not in
right. When the Clinton administration in 1993 and 1994 proposed universal health care, right, the Republican counterproposal was basically the ACA. Which apparently was not unconstitutional then, but is totally unconstitutional now. No, I mean, I think universal, Medicare for all, whatever you want to call it, those are all the idea in all those cases is that it's government-funded health insurance. And that's just, that's spending clause. That's not commerce. That's not necessarily proper. That's just, we are paying for you to have health insurance.
Pierre Delecto, what a world we live in. If you don't know, that's Mitt Romney's lurker Twitter account, Pierre Delecto. C'est moi, as they say. Anything else? All right.
Well, thank you, guys.
Thank you. Thank you.